Assalamu alaikum and good evening, viewers. Welcome to another session of Legal Ease, where we try to make the law as understandable as possible. Today our topic is on strikes. We're going to talk about strikes in South Africa. Strikes in South Africa is not something new, but because of the Pick It Up strike recently, we thought it would be a good idea to talk about strikes, to talk about the legal aspects of strikes, to talk about the labor relations and industrial relations aspects of strikes. When can people strike? What are the consequences of strikes? And to assist us with that, we have Nasreen Jajbhay, an attorney with Yusuf Nagdi Attorneys in Johannesburg. She's a part-time commissioner at the CCMA, so she has extensive experience with strikes. Nasreen also chairs disciplinary hearings for companies to ensure that they do not get into trouble with the law. I'd like to welcome Nasreen Jajbhay to the program. Nasreen, welcome, and assalamu alaikum. And we're going to be talking about strikes, as we said. Now, strikes, we know in South Africa, is not a new thing. Historically, if you look at strikes in as early as 1922, there were political strikes in South Africa, and at that time, of course, it was mainly white mine workers, and the way the government dealt with that, they called out the troops, they fired at people, they killed people, and that resulted in a change in government. The Smuts government was out, a new government came into power, and in 1924, the establishment of a collective bargaining system. So although at that time, black workers, including Indian and colored workers, were excluded from the collective bargaining system, but the collective bargaining system was established at that time. Recently, however, we've had strikes. The Pick It Up strike, for example, we've had. Now, there are strikes that are protected, there are strikes that are unprotected. Could you tell us, how does one go about having a protected strike? What is a protected strike and what is an unprotected strike?
Okay, wa alaikum assalam wa rahmatullahi wa barakatuh to Professor Mahamed and to our viewers. I thank you very much for this opportunity. It is so humbling and it's such a privilege. Professor Mahamed, you speak about strikes, and I thought I'll just delve into just a bit of background about a strike. Now, one must look at the right to strike, and this right to strike is one that is entrenched in our Constitution, with specific reference to section 23(2) of the Constitution 1996, and this is linked to Schedule 8 of the Code of Good Practice, and it lays down the regulations for rendering a strike to be protected. Now, why this is an important development is because previously there was no right to strike, and what would previously occur is that employees would engage in strike action, and because they were not protected, that would result in them being dismissed. Now, the development of the Constitution, the advent of the Constitution 1996, together with the Labor Relations Act, in particular Schedule 8, now affords protection to employees. So what this means is, if they follow the regulations as set out in the Code of Good Practice, this would mean that they would be protected if they embark on strike action. And if they are dismissed, that would result in an automatically unfair dismissal. So let us speak more about what is a protected strike and then what is an unprotected strike. Now, a protected strike, we look at section 64 of the Labor Relations Act. We also look at Schedule 8, as I've mentioned before. Quite simple, it's about procedure. What the union or the collective employees working together should do is basically have a referral for a mutual interest dispute to the CCMA or a relevant bargaining council. Now, once you refer the dispute to the council, the matter is set down for conciliation. At the conciliation stage, one needs to see whether you can resolve the matter amicably. If you do not, a certificate must be issued. And because it's a mutual interest dispute, within 30 days, that certificate must be issued. Now, that certificate is very important. That certificate must be attached to a notice, and that notice must be given to the employer 48 hours before you want to embark on a strike, and in the public sector, 7 days before. Now, that's what the Labor Relations Act speaks about. Further, the Labour Court in the South African Airways case also makes reference to another requirement. They say it's not just sufficient to say this is the notice, but also detail what is the issue in dispute. Why are we embarking on protected action? So that's what will constitute or render a strike to be protected. Now, on the opposite side is an unprotected strike. Now, an unprotected strike, also known as a wildcat strike. Now, this is a strike where you do not follow any form or any procedures, and it is a form of misconduct in terms of Schedule 8 of the Labour Relations Act. Why it is very important to follow the protected route is that now you open yourself up to disciplinary action, and this could lead to dismissal.
Okay, so in other words, employees have a dispute with the employer, and you said it's a mutual interest dispute. So in other words, employees want an increased salary, and I presume that's an interest, because the law doesn't say you must get an increase. So they want an increase from the employer, and the only way they can do that is to ask the employer, and if the employer says no, to put pressure on the employer by going through strike. And you also then mentioned, just for clarity for the viewers, that what the employees need to do is refer that dispute to a relevant bargaining council if there is one, and if there isn't, to the CCMA. The commissioner at the CCMA, I assume, then deals with it at conciliation, as you said.
Yes.
If the matter is not resolved, the commissioner issues a certificate. Parties can then go on the protected strike.
Yes.
Okay, but you then also said they are protected, they cannot be disciplined, they cannot be dismissed. But you said if it's an unprotected strike, they can. For example, the pick it up strike at the moment, we read in the newspaper that's an unprotected strike.
That is correct.
Let's assume an employer came to you and said, my employees are out on an unprotected strike. What can I do as an employer?
Okay, I would say that there are various options. The first is one needs to go back to Schedule 8, in particular Item 6 of the Code of Good Practice. And what it says is that if you do not follow the procedures in Schedule 8, then this is a form of misconduct. Now, with a form of misconduct, we often have this illusion that this means that it would warrant dismissal. That is not always the case. With any form of misconduct, one must look at whether there is a fair reason. That is what our labour laws are about, fair reason and fair procedure. So the courts will look at certain factors. Now, what is a fair reason? The three factors that we must look at is the seriousness of the contravention. Then we must look at whether the union or the employees, what attempts were made by them to comply with the act. And then thirdly, we see, did they embark on industrial action as a result of some unjustified act by the employer? Once we've established that, then it is important for us to understand that if the union is involved, they are the first point of contact. The employer must then notify the union. These are the steps that I'm going to take, and issue an ultimatum. Now, what is an ultimatum for the viewers? An ultimatum is a demand, or it is an instruction telling the employees that they must go back to work. Now, if they fail to go back to work, then there will be disciplinary action against them. And now, disciplinary action can take the form of a disciplinary hearing. But now we speak about the pick it up strike, and we think practically, you have 4,000 employees on a pick it up strike. Is it practical to have an individual hearing for each employee? And the answer is no. We also think about SAMWU's request. They said we want interpreters for the 11 official languages. So obviously we have some problems. Now the Act talks about fairness, about representations. So I would advise a client that that is not the only route to take. You could have a collective discussion where you, the employer, and the trade union engage, where the union is allowed to make representations. You also have another form where you can issue a letter to the employees and allow them to make representations. Why is it that I should not be dismissed? My services should not be terminated. So that is the one aspect. That is not the only aspect. The second aspect is then adjudication at the Labour Court. So you could launch an urgent application at the Labour Court, and for the viewers, you would ask for an interdict. Now, if that interdict is granted, it is an order that forbids you from partaking in strike action, from engaging in any form of violence, incitement, destruction to property, and it is one that you need to abide to. And if you do not, you may be held in contempt. So that is the other option. And what often happens in practice is if you go that route and if you are successful in attaining that interdict, then the union may be held liable for costs. So costs may be damage to property, any costs incurred as a result of that action. The third is then a lockout, a defensive lockout. When we speak about a defensive lockout, we speak about an action that's already taken. There already is a strike. What does the employer do? Collective bargaining. Collective bargaining is about a balance of power. So when we look at employees, when they are striking, they are holding that power. However, if you are locking them out, the employer now, the power balance now shifts. And with the defensive lockout, that also could be something to assist the employer. So I think that there are few options available on the table when dealing with such action.
Okay, so the employer gives the employees an ultimatum. It clearly, you said it could be in writing, could be through the union, but the employees need to be aware that the ultimatum is given, they're given a time, either come back to work or disciplinary action could be taken. And that disciplinary action could be a dismissal as well. Okay, but we see now in the Pick It Up case, because I suppose there are so many employees, it's going to be difficult to dismiss the employees. What other possible invention is possible for a case like that?
Well, with the recent amendments, the 2014 amendments, we now have an invention or intervention where the CCMA can now get involved. Previously, to the viewers, what had previously occurred is that you would need an agreement by the parties concerned to seek assistance from the CCMA. Now it's no longer like that. The CCMA, if it's public knowledge and they feel that they need to intervene, then they do in terms of Section 150. And that is actually currently, it happened today. There was a discussion, obviously we are not privy to that information right now, but it is something that could assist the parties. I mean, the strike action is one that goes back to 2015 November. We've seen 3-4 possible unprotected strikes. And so that is something, a new concept that I think will really assist.
Okay, could we stop there for a while? We'll take an ad break and we'll come back after the break and continue with the Section 150. Assalamu alaikum viewers and good evening. Welcome back again. We're talking about strikes. We ended just before the break talking about the Section 150 where the CCMA intervenes through the process of conciliation. Nasreen, can you tell us a bit more about this process at the CCMA in terms of conciliation?
Well, conciliation is a concept that we derive also from the Labour Relations Act. And it is one that speaks about a concept called statutory conciliation. So what happens with all matters is that you have the first leg of a process, which is statutory conciliation, where you try to resolve the dispute. So what the CCMA has now done is they've tried to incorporate that to assist the parties. Simply put, a CCMA conciliation is a very informal process. It is off the record, it is without prejudice. That means that nothing is on record, nothing can be used in subsequent discussions or in labour court litigation or at arbitration. And what the Commissioner will try to do is separate the parties, try to understand, gain the trust, the rapport of the parties, and understand how far apart are they. And I think it is something that will greatly assist the parties. If not, I would think of, we can speak a little bit about essential services. And, with the rat infestation, with the stench, with the businesses losing clientele, I think that it may be an option for Pick It Up to perhaps approach the ESC. And for the viewers, the ESC is the Essential Services Committee. This is a specialized unit. It is a unit of senior convening commissioners, CCMA commissioners, and they are a panel that will make a decision. They declare who is an essential service. And maybe if we can just touch on, for the viewers, what an essential service is.
Good idea. That's good.
An essential service basically is that service where any interruption to that service will cause an endangerment to life, to safety of a particular portion of people or population at large. So they are prevented from embarking on strike action. The recourse they have is if you have a mutual interest dispute matter, you would then have to go through conciliation, as we've touched on, and if that fails, you go to arbitration and a binding award is then given. So similarly, in this context, because we see that the Pick It Up strike has now health risks, I've read in articles where little children are complaining about tummy aches, especially in the areas that are not developed. And, if you think about, we're talking about rats, we're talking about insects. Rats spread diseases. There's something like 35 diseases that a rat can hold. And it can spread it through fecal droppings and through urine. And so that's why I say that because it poses a health risk, maybe if this intervention in terms of Section 150 does not work, maybe let's approach the ESC and see if we can resolve it in that manner. What do you think, Professor Mahamed?
So the employer would have to apply for that to the Essential Services Committee. The Essential Services Committee then looks at the impact that the strike is having, and in this case you mentioned rat infected, so it's causing harm to people, so they could declare it an essential service. Yes. You then also said that if it's then an essential service, they're not allowed to strike, then the dispute procedure moves from conciliation to compulsory arbitration.
Yes.
Okay, so is that an option in a case like this?
Well, I don't think that it's something that has been utilized before. But we must be innovative, and I think it is an option that perhaps the CCMA should look at, or the employee and the employees must look at, because we're now on the 4th week of the strike. It's 4,000 people that have been affected, and it's not as easy as just, it's an unprotected action, let us just go through the disciplinary route and dismiss these people. A strike itself has this overarching ramifications, not just on the employees, but the stakes are invariably high, both on employees, because you are losing your job. As part of speaking about protected and unprotected strikes, for the viewers, just to explain to you that when employees embark on strike action, whether protected or unprotected, they are not paid for their services. So it is a long drawn process. They are not affected just by themselves. They've got families, their livelihoods, businesses are affected. What happens with businesses is if you don't have the labor, there's no production, there's no profit. So the economy also suffers. Then we also have businesses. We've spoken about the restaurants that have recently been complaining about the strike action, pick it up workers. I've read several, employers saying that they've lost clientele. I've read complaints by the public at large. Previously, before we had this waste management collection by independent people, the individuals had to source it for themselves. They had to get rid of the waste by themselves, and they had to incur that fee. Now, who pays for that fee? They don't get reimbursed. So I think that when we look at strikes, we must look at it holistically and understand that it does have overreaching ramifications. And there are mechanisms that are in the Labour Relations Act. And I think it would always be best to revert to that and look at those rights and perhaps go through, at this stage, with the Pick It Up strike, we're already too far. It's really unprotected action. We need to speak about going forward. And so that's why I think intervention, if that fails, perhaps let's look at the ESC. Maybe they could assist us.
And I assume there's pressure on both sides. The employers are feeling the pressure because they don't have the production. The employees are feeling the pressure because they're not earning. And obviously, no food on the table, they have to pay their rents, they've got expenses. So they probably at a stage now where they're keen to try and settle, and this assistance by the CCMA will get them to assist. But you raised something important. They've got temporary workers doing the work. They're allowed to hire temporary workers. We've also heard that the striking workers are intimidating the workers that are filling in for them. Now, you've said if it's a protected strike, they cannot be disciplined. However, if an employee who is on a strike, irrespective of whether it's a protected strike or unprotected strike, is guilty of some form of misconduct and the employer can show that, does the employer have jurisdiction to do anything about it? Or can the employee say, I'm not at work, I'm outside the workplace, so the employer can't do anything about it?
No, Professor Mahamed, whether it's a protected strike or an unprotected strike. You see, when we speak about a protected strike, we're saying that embarking on that strike action, that is protected. However, with a protected strike or an unprotected strike, where there is misconduct, and maybe when we speak about misconduct, I know that the newspaper articles often talk about illegal action, unlawful action, and I think that the viewers must understand that the terminology that the Labour Relations Act speaks to is protected and unprotected strikes. They don't talk about illegal legal action. But in any event, what the newspaper articles are referring to is those acts of misconduct, the violence, the intimidation, malicious damage to property. And yes, the employer can discipline them, whether they are in a protected strike or an unprotected strike. And that is also where urgent interdicts would greatly assist the parties.
Okay, and that's the appropriate time. We take time for a break. Listeners, we'll have a break, and after the break, we'll continue the discussion. Viewers, assalamu alaikum and good evening again. We continue with the program. We're dealing with strikes, and now we invite you to call in, please. If you want to call in, the number will appear on the screen. The number is 011-086-7777. You're welcome to call in and ask our guests any questions related to strikes, related to employees. If you may have employees who want to go on strike, what you can do, or what employees can do if they want to put pressure on their employers for increased salaries. Okay, we were talking about the Essential Service Committee. We said it could be declared an essential service if the committee so wishes because of the danger to life. And if that's the case, we said that the procedure would then be conciliation and compulsory arbitration. We also find sometimes that a group goes on strike, but members of the same union working in another organization support the strike, and they go on what is called a secondary or sympathy strike. Can you tell us what a secondary or sympathy strike is, how they go about having it, is that protected, what must they do to ensure that it's protected?
Yes, of course, viewers and Professor, a secondary strike is basically where you have this relationship between a customer and a supplier. So for instance, you've got company A and company B. Company A, for instance, they provide a liquid, and company B will then bottle that liquid. Now what happens is company A has they've got some concerns, they've got a grievance, they want an issue to be resolved. Generally, it's about salary increments. It may be because of conditions of employment. And what happens is they have the interest in a matter. Now, a secondary strike is where company B, even though they don't have any interest in the matter, they want to gain support for company A. And what is important and a requirement is that the first strike, the strike by company A, must be a protected strike, as we've spoken about earlier. Compliance with procedures, going to the CCMA, getting that certificate, and then you give notice to the employer. Now, similarly, the secondary strikers also need to give the employer some form of a notice, and generally that is 7 days. What is important is that there must be this link. Now, them going on a secondary strike or a sympathy strike means that they would also have to, they have to make sure that there is a financial impact, either direct or indirect, on the employer's business. And so that's how I can explain to you what a secondary strike is. And if you follow those procedures, that makes the strike a protected one.
Okay, you said for the primary strike, the procedures, you go through CCMA or to the bargaining council. If there's no settlement at conciliation, they give 48 hours written notice. But the secondary strike is different. The primary strike needs to be in place. There needs to be a protected primary strike. then the employees of the other organization can have a secondary or sympathy strike. And the only thing they have to do is give their employer notice.
That is correct.
Okay.
And there must be that link. So remember, because it's a customer and a supplier, you must have that impact. So there's no point if they are undertaking a secondary strike, they must have some purpose. So there must be that link. You must put some pressure on company A.
Okay,
and
so it must be a supplier or
yes.
Okay, so because that then will put pressure on the primary employer
Yes.
if the employer doesn't get supplies. Because even while there's a strike, they hire temporary labor and they can continue with production.
That is correct.
Okay, so the secondary strike will put an end to that use of secondary labor to continue with production. Okay, this essential service, I know you've spoken about it, but it is important. Generally, you've indicated that workers cannot strike during an essential service, if they're working in an essential service. You've explained what an essential service is. Now, for example, the police, that's an essential service.
Yes.
But we've heard that police go on strike sometimes. How does that happen, and what do you do in a case like that? Or if the pick-it-up workers continue striking even after it's been declared an essential service, what can the employer do about that?
Well, I suppose, look, they've got to go through the conciliation, because they cannot strike, they must go through the mechanisms. And the mechanisms are simply this: they must go through conciliation. If conciliation fails, remember, conciliation is the first leg. Can't reach a settlement, you go to arbitration. At arbitration, then that award is binding. And I suppose if they don't comply with it, then we have contempt. And what we didn't mention was the fact that this also applies to the state. So if the state, for instance, is one of the parties in this dispute that we speak about, this mutual interest dispute, then that award is somewhat different. What happens is, if the state is one of the parties, then that award which is issued by the arbitrator is a binding award, but it only becomes binding 14 days after it has been issued, unless the parliament decides that they have a different resolution. Or, for instance, if Parliament finds that arbitration award is not binding, in that event, we start the process again. We go through conciliation and then we go through arbitration. So that is quite important. I think what is also important, and maybe for the viewers for interest, is that you get essential services which protects, the interruption relates to health, safety of persons. Now you get a maintenance service. And I don't know if we'd like to discuss with the viewers.
That's different to an essential service.
So similarly, the concept is almost the same, but if we look at what the interruption relates to, it's quite different. What happens is, with a maintenance agreement, you will get a company that will apply or go to the ESC and say, look, I can't have my employees engaging in any form of industrial action, and that would mean that they would also not be able to have any lockouts. And they are saying that if we have this interruption, what it does is it relates to a physical, material destruction of the workplace or the machinery. So what they try to protect is then that means, not just finance, but the means. And what will then happen is they will apply to the ESC. If the ESC finds that they can be declared a maintenance service, then those employees similarly, they can't engage in strike action. The route of action they would have to take is that they have to go through conciliation and arbitration.
Okay, one other thing, we often hear COSATU, for example, with the e-tolls, they're saying we're calling people out on a strike. Is that the same as a normal strike? Is that different? How does that work? COSATU calls not just one company. So they call everybody out on a strike. And I assume that's not the normal strike, that's protest action.
Well, basically, that is very different. It's different in that a protest action is where you are, as employees, you are protesting against the government, or you are protesting against the socio-economic interests of employees. And this action, this protest action, can also be protected, provided that you follow the mechanisms. So what is the requirements? The requirements are this, that it must be carried out or initiated by a registered trade union or a registered trade union federation, thereafter they must notify NEDLAC. So they must notify NEDLAC that they wish to embark on protest action, what form it will take, and the reasons for it. And that will culminate in a protected protest action.
Okay, NEDLAC, for the benefit of the workers, the National Economic Development Forum. It is made up of employer representatives, trade union representatives, and government representatives. So it is a tripartite structure. So the dispute would be with NEDLAC. If NEDLAC can't do anything about it, they then have to give notice, 14 days notice. They can then call people out. But the consequences are the same. If it's protected, you said, the employer cannot dismiss or discipline those employees. Okay, and those usually doesn't last very long, probably a day or two at most, because people are losing money. Okay, time for another ad break. We'll take a break and come back and continue the discussion. Assalamu alaikum. Good evening, viewers. We on our last 10 minutes of the program. We've been discussing strikes. We've talked about the Pick It Up strike. We spoke of protected and unprotected strikes. We spoke a bit about protest action, which is not a strike, but also workers are protected and can stay away. We spoke about protest action was the last thing, and we sometimes get questions, Nasreen, because employers want to know, I've got a corner cafe, I've got one employee, or I have a domestic worker. Now we know that they have rights in terms of the labor legislation. Can such an employee go on strike as well?
Professor Mahamed and viewers, this is quite a common question. Now, one always needs to go back to the definition of a strike. And in terms of Section 213 of the Labour Relations Act, they make reference to a concerted refusal to do work. So that means it's a collective effort. So it must be more than one person. So no, Professor Mahamed, one person that wants to down tools, that will not be considered to be a strike.
Okay, so the individual employee, the individual domestic worker cannot strike because you need more than one person
That's
to strike.
correct.
Okay, and they can't get together with the neighbor's domestic worker and go on strike because it has to be
the same employer.
But if you've got a gardener, then the domestic worker and the gardener can get together perhaps and strike. I'm not sure whether that would put pressure on the employer or not, but they would have that right to strike. Okay, so viewers, just a reminder that you could call in. The number is 011-086-7777 if you have any questions for our guest, Nasreen, about strikes or any matter related to labor disputes. Now, workers for wage increases, in other words, for mutual interest disputes, because normally for other disputes, if somebody is dismissed, the dispute procedure is conciliation and then arbitration. Or if it's an automatically unfair dismissal, the procedure is conciliation and then perhaps the labor court. But for mutual interest disputes, it is conciliation and then strikes. And strikes obviously is an essential part of the collective bargaining process.
Yes.
Why is that?
Well, if we look at what collective bargaining is, and with conciliation, it doesn't just end there. So I would say that if conciliation fails, there are two options, not just strikes, because strikes are the product of employees, but also lockouts. So what happens is it could go either way, either strike action, industrial action, or lockout. Now, it's an essential tool because with a lockout, for instance, with an offensive lockout, it is important to understand that it gives that employer power. So if you are on the negotiating table and we reach a deadlock and the employee does not, or the employees do not want to accept a demand, you could lock them out. It's called an offensive strike to compel them to accept that demand. An offensive lockout also would be where, for instance, if the employees are intending on embarking on a strike and you want to prevent that from happening, then you would also you will also institute an offensive lockout. Now, if you look at collective bargaining, and strikes as a whole, it is important. It's a bargaining tool. And what it does is it balances the power. So if I could just maybe explain to the viewers what I mean by that. Now, if we look at the relationship between employer and employee, we often know that the employer is inherently the stronger party. Why? Because it has the capital. It's got the capital to back them, they've got the finances, they make the decision. So ultimately they're in a stronger position. They make the decisions. But what happens with the strike? Now the strike balances the power where the employees, if they have a concerted refusal not to work, this affects your production, this affects your profit. So ultimately we have that balance of power. And so that's why collective bargaining is important. It relays change, and sometimes that's all we really need. Now on a similar note, when we speak about the power, and we touched on this earlier, the other way to shift that balance from the employees to the employers is by way of lockout. So I think that we wouldn't be able to do away with strikes. It is an essential part of collective bargaining, and I believe that it is something, it is a tool for making a difference.
Okay, you've mentioned it previously, but just a reminder to the listeners, can you tell us again, if there's a protected strike or a protected lockout, do employees get paid during the protected strike or during the protected lockout? Okay.
Now, with protected strikes, it's basically the principle of no work, no pay applies. But what happens is if you are being remunerated in kind, so what I mean by that is in terms of food, in terms of accommodation, then the employer will still have to make sure that they give the employees the food and the accommodation. And I think what's also important about that is the no work, no pay principle applies, and also replacement labor is also very important. So one needs to draw a distinction. When we talk about protected strikes or even unprotected strikes, one is allowed to get replacement labor. There is no ban on that. However, if we're talking about offensive lockouts and defensive lockouts, then we have a bit of a difference. So with the offensive lockout, you cannot get replacement labor. Why? Because the employer is instituting the action. Now with the defensive lockout, basically they are responding to something that has already occurred. So they are responding to the strike itself, and that's when you can get replacement labor.
Okay, so with a strike, because employees have a right to strike, they can go on strike. The employer can hire scab or replacement labor, but because the lockout is not a right in terms of the Constitution or in terms of the Labour Relations Act, although the employer has recourse to the lockout. If it's an offensive lockout, the employer cannot hire scab or replacement labor. Okay, we've been through strikes. We spoke about the early strikes in 1922. We spoke about strikes in 1972. There were major strikes that brought about changes, and the strikes happened in Durban. Viewers, we spoke about strikes and collective bargaining, and that strikes are an essential part of the collective bargaining process. Similarly, lockouts are an essential part of this collective bargaining process, because without the right to strike, you couldn't have effective collective bargaining. You would, in fact, as somebody once said, have collective begging, because workers would have to go on their knees and say, please pay us more. And then we also spoke about what an employer can do if employees are guilty of any misconduct at the strike, even if they're not at work. We spoke about whether employees need to be paid or not paid, and clearly you said to us that employees do not get paid. The rule is no work, no pay. They don't get paid when they're on a strike, irrespective of whether it's a protected or unprotected strike. You've said that employer can hire temps, and we've seen that happening now with the Pick It Up strike. You've explained to us about secondary strikes, what secondary strikes are, where you have a sympathy strike in a different company, provided there's a link. We spoke about the lockout and the essential services and the possibility of the Pick It Up situation being declared an essential service. We're almost at the end of the program. Is there anything that you would like to tell the viewers as a final closing, what they can do, especially small employers, if they have a strike, what they do? And we've got perhaps about less than half a minute to go.
Well, I think that it's just important to understand your laws, to understand the acts. You must remember that the Constitution is our supreme law of the land. So always make reference to that. That is your guiding points. If you don't know what to do, you go to the Constitution. If you're dealing with labor-related matters, look at what legislation governs labor. And generally, you'd have the Labor Relations Act, the Basic Conditions of Employment Act, Employment Equity Act. And that always seems to guide us. And I think what is important for the viewers is that it's always important to empower ourselves, to understand the law. And in that way, for both employers and employees, I find in practice that if people understand their rights, then you often don't find a lot of challenges within the workplace.
Okay, Nasreen, thank you very much for making yourself available. It's been very useful. Listeners, we've come to the end of the program. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam wa rahmatullah.